Welcome back to Holocaust, Genocide, and International Law. This is Class 5, Legal Reckoning with the Crimes of the Holocaust, the Civil Process. Here's the breakdown of today's lecture. In Part 1, we're going to have a recap or an overview of the process of stealing or theft that we touched on in Class 1 when we looked at the laws the Nazi Party enacted to facilitate the perpetration of the Holocaust. In Part 2, we'll look at wartime restitution efforts, so efforts on the part of governments during the war to prepare themselves and others for the process of restitution after the war had concluded. In Part 3, we'll look at the first period of restitution. This encompasses what Professor Baszler calls in his book Periods 1 and 2 and spans from 1945 through the 1960s. We'll look at this first period through the lens of Germany, Israel, as well as a couple of other exemplar countries in Europe. In Part 4, we'll look at the second period of restitution, which I'm calling 1990s through present, and we'll look at efforts made on the part of Eastern European countries that emerged from behind the Iron Curtain, also East Germany, and in particular, efforts made by the United States to facilitate the Holocaust restitution process. And in Part 5, we'll conclude with looking at why the U.S. Holocaust restitution model that emerged beginning in the 1990s and has continued until today has largely failed to work for other historical atrocities, and we'll go through a number of examples. Let's get started. Recap of Class 4, Legal Reckoning of the Crimes of the Holocaust, the Domestic Criminal Process. Last class, we looked at the domestic criminal process for holding perpetrators of Nazi crimes accountable. We looked first at two cases from Germany, where there was a general reluctance to hold trials and provide criminal accountability for the crimes of the Holocaust. But for the two cases examined, the actions of the Nazis in territory outside of Germany was brought to the domestic conscience of Germans. German domestic law for crimes such as murder and manslaughter were used to prosecute the alleged perpetrators of the crimes of the Holocaust. By contrast, we then looked at the case of Adolf Eichmann, who was captured by Israel and Argentina and then made to stand trial in Israel on the basis of a domestic law called the Nazi and Nazi collaborators law for a crime that was strikingly akin to the crime of genocide under the Genocide Convention, but in this case, the protected group was the Jewish people. We concluded by having the opportunity to get Professor Baszler's insights into domestic prosecutions of Nazis in Poland. Now, let's move on to Part 1, Recap or Overview of the Process of Stealing or Theft. In Class 1, we looked at the passage of legislation that curtailed the rights of Jews and other targeted groups in Germany and other occupied countries during World War II, and how the passage of legislation perhaps facilitated the Holocaust. Law and Nazi policy likewise covered the attendant theft of property from Jews and other targeted groups, and this included state-sanctioned economic boycott of businesses, as well as the requirement of detailing property on government forms. This was essentially where Jews and other targeted groups were required to prepare their own inventory lists of their assets, which later facilitated the theft of their assets by the Nazis. Other examples of stealing or theft as part of Nazi policy included the establishment of state entities in charge of managing liquidated assets. An example of this was Italy's Office for the Management and Liquidation of Real Estate, also known as HGAIL. It was set up in 1939 by the Italian government, but was largely unused between 1939 and 1943, after which the armistice agreement was signed with Italy and the Nazi-controlled Italian Social Republic was established in northern Italy. So around November 1943, the German command ordered the arrest of all Jews and the confiscation of their property for the benefit of those who lost property in enemy or allied air raids. And then at that point, HGAIL was busier, and it was sort of the repository of liquidated assets and other seized properties. in an interesting twist of history, if you will, the entity HGAIL that was in charge of managing these looted assets during the war was then charged with returning all of the assets after the war. This was the case in a number of other European countries where the repository of looted assets during the war was then sort of used in the opposite capacity after the war to return property with varying degrees of success. Also, another factor in stealing or theft as part of Nazi policy was the relinquishment of assets in exchange for exit visas. Professor Basler describes this phenomenon in his book with the example of Austria's Central Office for Jewish Immigration, which was a sort of one-stop shop for dispossession of assets, at the conclusion of which you left with an exit visa and nothing else. Another example of the theft as part of Nazi policy was that property in occupied territories was taken and sent back to Germany. And contrary to sort of general understanding, it wasn't just the property of Jews that was looted. Peter Hayes, in his book, The Oxford Book of Holocaust Studies, describes this phenomenon in the following way. He says, World War II was robbery on a scale scarcely seen in European history, the more so because the plunder of the Jews outside of Germany during World War II took place alongside the looting of even greater quantities of precious metals, stocks and bonds, cash, artworks, enterprises, real estate, and labor from non-Jewish sources in the occupied territories. So outside of Germany, it was the theft of the property of Jews and non-Jews on a tremendous scale. And for avoidance of doubt, when we're talking about theft, we're speaking about the theft of movable and immovable, or, for example, real estate. Because I think it's really easy to overlook when we read news stories in newspapers today, the immovable property aspect of the theft. There was a tremendous amount of real estate and businesses that were stolen pursuant to Nazi policy that were, some of which that were given back after the war, and a large proportion of which still have not been returned. So when we see in the news that there have been new troves of very famous artworks uncovered, it is good to keep in mind that it wasn't just artworks and stocks and bonds and gold and jewelry that was taken. It was also homes and other real estate. Part 2, wartime restitution efforts. Even while the Nazis and their Axis cohorts were looting property in occupied territory in Germany during the war, the Allied powers and governments in exile of the occupied countries were making efforts to set restitution goals during the war. And when we talk about restitution during this lecture, we're going to use it interchangeably with the term compensation. And the two concepts, restitution and compensation, are really subcategories of the term reparations. Reparations being a broad concept encompassing restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. So we're going to be using many of those terms interchangeably throughout the rest of today's lecture. So what were these efforts that the Allied powers and the governments in exile put in motion? The first one was the London Declaration of 1943, where 17 governments reserved the right to declare invalid property transfers made during the war. In addition, governments in exile that were located in London issued decrees annulling German laws that confiscated property in their countries. In addition, armistice agreements signed by the Allied powers and the defeated Axis state included requirements to repeal discriminatory legislation. An example of this would be Article 6 from the Armistice Agreement with Romania, which required Romania to repeal all discriminatory legislation and restrictions imposed thereunder. This provision, at least for Romania, was particularly relevant for post-war restitution because Romania's wartime Antonescu regime had confiscated Jewish urban and rural property through a series of racially discriminatory laws. In addition to the actions of the Allied powers and the governments in exile, the World Jewish Congress was also calling for restitution even before the end of the war. In 1944, Jewish leaders in the United States and Mandate Palestine were concerned with the issue of property restitution, and the World Jewish Congress called for uniform laws on restitution to be enacted in all territories formerly occupied, annexed, dominated, or influenced by Axis powers. So there were interest groups, there were governments in exile, there were Allied powers, all thinking ahead, even before the conclusion of the war, to restitution policy. What was said about restitution at the conclusion of the war? If we look to the so-called Paris peace treaties that were signed between the Allied powers and the defeated Axis states, including Bulgaria, Finland, Hungary, and Italy, the peace treaties included specific restitution requirements. For example, Article 26 of the Treaty of Peace with Hungary required property taken from the United Nations either to be returned to the owner, or if it could not be returned, then the Hungarian government would be obliged to pay the owner 2/3 compensation. In addition, Article 27 of the same treaty required that property confiscated on account of the racial origin or religion of such persons was to be restored, or when that was not possible, fair compensation was required. Thus, the right to property restitution as a remedy for looting and confiscation was repeatedly recognized and confirmed both during the waning years of World War II and thereafter. But what about before World War II? What was the status of the law of restitution or remedies for the stealing of property? What did international law say about reparations? Let's look back at the pre-World War II existing state of the law and even back centuries prior. Remedies for property-related violations date back to Roman law, and so these were not new legal concepts in the post-World War II period. In fact, particularized references to reparation by a government to its own citizens have been traced to treaties as far back as the Treaty of Westphalia. The appropriate remedy is to return the situation to the status quo ante, that, in the words of the PCIJ in 1928, the reparation must, as far as possible, wipe out all consequences of the illegal act and reestablish the situation which would, in all probability, have existed if that act had not been committed. So, what was taken must be returned, and if it cannot be returned, full compensation must be paid. However, as we'll see, despite the legal mandates being in place before the end of World War II, and the laws enacted after the war, which we're going to look at, the value of what was returned rarely equaled what was taken, and that fact is reiterated and underscored by Professor Basler. So, a question to consider is, if the principle is that the situation must be returned to the existing state of affairs, the status quo ante, has principle and practice diverged with respect to Holocaust property restitution? And if so, how? Part 3, first period of restitution. We're going to look at Holocaust property restitution as having occurred during two main periods. We're going to collapse the first and second periods that Basler describes into one period, 1945 to the 1960s. And then we'll discuss a second period that occurred between the early 1990s and present day. Let's look first at the first period, the immediate post-war period between 1945 and the 1960s, and first at Allied occupied Germany. The chief focus of the Allied powers was to figure out what to do with the vast amounts of stolen property that was located within defeated Germany. The Allied powers had divided the country into 4 occupation zones, but efforts to enact a restitution law that applied to all 4 zones failed. So each zone enacted their own, and they were collectively known as the Allied restitution laws. So in the U.S. zone of occupation in 1947, military government law number 59 on restitution of identifiable property was enacted. The law permitted restitution claims from any person, regardless of citizenship, whose identifiable, movable, and immovable private and communal property was confiscated between 1933 and 1945 on account of race, religion, nationality, ideology, or political opposition to National Socialism. The law required restitution of property irrespective of whether it was in the hands of the state or third parties. When we look at immovable property restitution, the category can be further subdivided into 3 main types of property: private property, communal property, and heirless property. Private property is just as it sounds: private property, private holdings of homes, businesses, farmland, etc. Communal property is property owned by religious organizations. It can include temples or other houses of worship, but also religious schools or hospitals or cemeteries and things of that nature. The final type of immovable property is known as heirless property, and it's property that does not have any living heirs to claim it. And with this type of property, most European states during World War II and also now had laws stating that if there were no heirs to claim the property would escheat or return to the state and essentially be owned by the state treasury. But after World War II, there was this belief that if the government had a hand in bringing about the situation where there were no heirs to claim the property, they shouldn't be able to benefit from the heirless property becoming part of the state. So in Germany, heirless property was dealt with in a separate manner than just returning to the state. Shortly after the US enacted their restitution law in 1947, the French zone and the British zones also enacted restitution laws. But the Soviet occupation zone, which later became the German Democratic Republic, or East Germany, did not enact a restitution regime. So basically, between the end of World War II and reunification, there was no restitution process in East Germany. But what about communal and heirless immovable property? As we discussed, there are two different types of real estate. And restitution of communal property in the Western occupation zone and also later in the FRG took place under the framework of the Allied restitution laws. The laws, which we described briefly, also gave power to so-called successor organizations to manage communal and unclaimed or heirless property. The successor organizations in the Western occupation zones were the Jewish Restitution Successor Organization, the JRSO, in the American occupation zone, the Joint Trust Corporation, JTC, in the British occupation zone, and the JTC French branch in the French occupation zone, with a joint branch for property located in Berlin. The Allied restitution laws empowered these successor organizations to file restitution claims and use the proceeds from successful claims to provide relief to needy survivors worldwide. And this model of using unclaimed and heirless property for the benefit of survivors worldwide has been extended to other countries in Europe and is encouraged for countries that have not yet enacted a method of providing restitution or addressing heirless property issues in Eastern European countries in particular today. Looking at what happened with restitution, after the establishment of West Germany. The Allied restitution laws remained in effect even after the Western powers merged their 3 zones of occupation into the Federal Republic of Germany in 1949. But additional legislation was enacted in the 1950s to kind of fill in gaps that weren't covered by the Allied restitution laws. For example, the 1957 German Federal Restitution Law provided for the compensation of property that was no longer traceable. And the 1956 Federal Compensation Act provided for compensation not covered by the restitution laws, including for those who had suffered bodily harm, damage to professional advancement, damage to property, and damage to business or professional career as a result of National Socialism. What was the status of property restitution in other European countries in the immediate post-war period? Let's take a couple of examples, the first one being Poland. Laws enacted immediately after World War II by the newly installed Polish communist regime included a 1945 decree annulling occupation judgments and a 1946 decree which gave Polish Jews and other groups who had been targeted during the Holocaust a 10-year window to reclaim immovable property confiscated during the German occupation. After 10 years, however, the property would then become part of the Polish state. So there were these laws that were passed which de jure reversed property confiscations, but regaining de facto control of the property often proved difficult. Aggression and threats became commonplace for former Jewish owners when they tried to retake possession of their property from non-Jewish residents who had moved in during the wartime Nazi occupation. The rationale behind the threats have been linked to a number of reasons, including lingering anti-Semitism and also a general fear of homelessness on the part of non-Jewish survivors of the war. The war had left Poland utterly ravaged, and there was a severe housing shortage. But whatever property was returned during and pursuant to this window of restitution was soon subject to a second wave of widespread confiscations. Nationalization laws passed by the Polish communist regime in the 1940s and 1950s this time confiscated property from all Poles, regardless of race, religion, or ethnicity. What was the early restitution situation in occupied countries in Western Europe? Let's take, for example, the Netherlands. The Dutch government in exile issued a number of decrees even before the war ended, setting up a restitution framework. This included a decree known as E100, or the 1944 Decree for the Restoration of the Rule of Law, which canceled laws enacted under compulsion during the occupation. The government in exile also enacted other decrees which set out hundreds of specific German laws that would be revoked, and also decrees that provided that property of enemy states and subjects would become property of the Dutch state. With this early framework in place, how did the restitution in the Netherlands unfold? Just as with most other occupied states, in the Netherlands the process was complicated. Historian Gerard Alders describes the difficulty in returning property. He says, restoring real estate to the rightful owners also gave rise to specific problems. When Jewish owners or their heirs were entitled to reclaim their property, questions arose about the individual who was to take the loss. If a building had been purchased by a Nazi or a Dutchman with Nazi sympathies, for example, a member of the NSB, the Dutch National Socialist Party, the answer was obvious. The first buyer took the loss, and the owner regained his property. Buildings that had been resold several times, especially ones where the original Jewish ownership had been kept secret, were a more complicated matter. The most recent buyer might have been unaware of the situation. In such cases, the Department of Real Estate of the Council for Restitution of Legal Rights would try to negotiate a settlement distributing the loss among the subsequent buyers. Often, however, such a settlement proved impossible. The case would be heard by the Department of Dispensation of Justice, legal fees mounted, ordinarily Jewish owners got their property back. So that's what Alders said about the restitution situation. So the restitution process in the Netherlands lacked some predictability, and the former owners of property could not always rely on the letter of the law to get their property back. In many cases, it was part of a settlement that the Jewish owner had to partially financially compensate the most recent buyer of the Jewish owner's property in order to get the property back, for example, with respect to losses on mortgages. Dutch historian Wouter Verhaert has also described another competing interest in post-war restitution in the Netherlands between 1945 and the early 1950s. In the instance that he describes, the Dutch Minister of Finance used the restitution machinery to mainly pursue the financial interests of the Dutch state in order to reconstruct the economy. And this was done even if the policy conflicted with the interests of the dispossessed Jewish community. The finance minister, with his mindset on the social economic reconstruction of Dutch society in general, did his utmost to protect Dutch financial institutions against claims during the post-war period. So you'll see there are these competing both public and private interests, which make property restitution complicated. And maybe again, just to go back to what we were discussing about what is the appropriate remedy for theft of property, the international law principle is the return to the status quo ante. The restitution legislation in the Netherlands, for the most part, was return of the property. But think about what these two historians were describing. Did the principle of restitution legislation diverge with the practice or the reality of what actually happened and what unfolded during this early restitution period in the Netherlands? What about Israel? Was there property restitution in the classic sense in Israel in the immediate post-war period? No. Property had not been taken, but there was an important reparations agreement, the 1952 reparations agreement between Israel and the Federal Republic of Germany, also known as the Luxembourg Agreement, which provided more than 3 billion Deutschmarks in assistance to Israel from West Germany. Under the agreement, West Germany was obligated to pay Israel reparations for the absorption of 500,000 Holocaust survivors. Israel received the 3 billion Deutschmarks and much needed goods and services, and in return, Israel waived compensation claims for Jews living in Israel in 1952. The Conference on Material Jewish Claims Against Germany, we'll call the Claims Conference, received an agreement from West Germany that it would enact restitution laws and that 450 million Deutschmarks would be paid to the Claims Conference, a pass-through entity, to be used for the benefit of needy Holocaust survivors living outside of Israel and for cultural projects. As Professor Basler describes, this agreement was revolutionary because it paid reparations to individuals, most of whom were not West German citizens. This was a politically charged agreement and decision by both states. Prime Minister Konrad Adenauer in Germany didn't even have the support of his party when making this decision, and in Israel there were protests to the country having accepted blood money in the agreement. Turning now to the second of the two main periods of Holocaust restitution, the 1990s to present. We'll look briefly at efforts from Germany and Eastern Europe, and then go into more detail with respect to efforts in the United States from the 1990s to the present. Turning first to Germany. As we previously discussed, prior to the reunification of Germany in 1990, no restitution regime had been established for property lost during the Nazi era that was located in the GDR, East Germany. An estimated 45,000 pieces of real estate and 10,000 businesses had been Aryanized in East Germany during World War II, and a further 3.5 million East Germans had left their homes and property after the war to resettle chiefly in West Germany. And industrial and agricultural property was also expropriated during the Soviet rule of East Germany and nationalize. So by the time we get to reunification, there's a really complex web of outstanding property issues that need to be addressed. So following reunification in 1990 was the passage of the Act on Settlement of Open Property. And in 1994, there was the passage of the Nazi Persecution and Compensation Act. The two laws together permitted former owners and their heirs of property that was sold under duress during the National Socialist period or confiscated by the Nazi regime to claim property located in the former GDR. Interestingly, judicial case law has confirmed that property initially confiscated in West Germany, but which later made its way into East German territory, was subject to restitution laws from the FRG or the Allied occupation or the Allied restitution laws, but was not subject to the 1990 Act on Settlement of Open Property issues. So what about Eastern Europe? I hate to make generalizations about more than a dozen countries in just a couple of minutes, but we don't have the bandwidth in this course to make a country-by-country scrutinizing examination of efforts from each of these countries. If you're really interested in property restitution, Michael Basler and I have a book coming out in January that addresses restitution measures in 47 countries from the end of World War II to today. But in the meantime, the following summary can be made regarding restitution efforts in Eastern Europe in the 1990s, actually until today as well. So after emerging as transitional democratic states in the early 1990s, the post-communist regimes of Eastern Europe passed private property restitution legislation with varying degrees of comprehensiveness and varying degrees of success. So the legislation covered both Holocaust-era confiscations and communist-era confiscations sometimes. Sometimes it only covered one or the other. Also, the amount of compensation received or the extent to which property could be returned in rem varied widely by country. In some countries, restitution measures happened almost immediately after the communist regimes were ousted, and for others, restitution measures were enacted only recently. For some countries, restitution was limited to citizens, while in other countries, restitution of Holocaust-era property was excluded, right? As I mentioned, maybe only communist nationalizations would be covered. In some states, only compensation was paid, and for a few, a catch-all fund was created to provide some, if only symbolic, compensation for those individuals who had been ineligible for other restitution schemes. So you see that there are a variety of issues that affect who and how much and when individuals from different Eastern European countries could make claims. Turning next to the United States. In the 1990s, the U.S. again became a key facilitator in Holocaust restitution. Holocaust survivors and their heirs filed lawsuits in American courts for return or compensation for stolen property, and this began a movement in Holocaust restitution that continues until today. There are particular challenges in bringing lawsuits against foreign countries in the United States because of the special challenges posed by the United States Foreign Sovereign Immunities Act. We call this the FSIA. The FSIA grants immunities from suit to states and their agencies of instrumentalities. So claimants, when they bring lawsuits, have to fit within one of the enumerated exceptions to immunity. The most popular and most frequent ones relating to Holocaust property restitution are the exceptions, the so-called commercial activity exception and the international takings exception. And the international takings exception being where the alleged property was taken in violation of international law, and the commercial commercial activity exception is essentially where government's actions are, the government is acting more like a commercial entity than engaging in a decidedly sovereign act. And under those circumstances, immunity from suit is abrogated, and then the foreign state has to answer for the alleged crime or violation in U.S. courts. The most well-known of these foreign sovereign immunities cases is that of Maria Altmann and her successful quest for the return of her family's treasured Gustav Klimt paintings from the Republic of Austria. This was dramatized in the 2015 feature film Woman in Gold. In the case Altmann versus Republic of Austria, the American courts decided that even though the paintings were not physically located in the United States, Maria Altmann's suit fit within one of the exceptions to immunity because the Austrian government entity holding the paintings was engaged in commercial activity in the United States. So, in addition to US-based litigation filed by private parties, in the 1990s, the political branches of the US government, both at the federal and state levels, also became involved in the Holocaust restitution movement, including with respect to claims for Swiss dormant bank accounts, Nazi gold that made its way to the US, insurance policies, German firms involved in gruesome medical experiments, and the large portion of German industry that benefited from slave labor. So you've got sort of like a political arm, political interest that was renewed in the 1990s, and also a judicial interest in filing these cases in U.S. courts. Why was the U.S. and U.S. courts a sort of key target in the 1990s for Holocaust restitution? This goes to what Baszler describes as his four-legged stool. Why the United States? Baszler describes first the 8 factors relating to why the U.S. legal system was primed for this kind of litigation. I'll just go through them briefly. You can look at them in more detail on your own. The first being the ability of foreign citizens to file suit in the U.S. for human rights abuses committed on foreign lands. The recognition of jurisdiction over defendants that do business in the United States, even over claims that occurred abroad. The recognition of class action suits. The ability of lawyers to take cases on a contingency basis, thereby giving Holocaust claimants top-notch legal representation when filing suits against European and American corporate giants. A legal culture in which lawyers are willing to take high-risk cases with low probability of success in order to test the limits of the law. Fixed and affordable court filing fees when filing a civil lawsuit. The ability to have a jury trial in civil litigation, and the existence of an independent judiciary that does not take so-called marching orders from the political branches of the government. So all of those factors sort of relate to why the U.S. legal system was primed and available for Holocaust restitution. But there are also 3 additional factors to Baszler's four-legged stool. The second is public officials placing a spotlight on Jewish property theft and slave labor and having it backed up by diplomatic pressure. Having Jewish organizations in the United States seeking restitution for Jewish theft. And American media maintaining a spotlight on the issue of looted assets. Now, looking quickly at the second factor, public officials placing a spotlight, beginning with Bill Clinton, there has been in the United States an Office of the Special Envoy for Holocaust Issues at the United States Department of State. The first special envoy was Stuart Eizenstat. Ambassador Eizenstat and the Office of the Special Envoy have helped broker large-scale settlement agreements with Swiss, German, Austrian, French, and other European countries addressing property restitution of all types and payments for slave and forced labor. Not all cases that were filed in the U.S. were successful, and settlement agreements that were reached often included symbolic justice instead of return to the status quo ante type justice, and an apology, which to many was far more meaningful than just the symbolic justice on its own. But in addition to the judicial aspect of Holocaust justice in the US in the 1990s, the United States government was also very interested. And this is reflected in the commissioning and conclusions of two reports called the Eisenstadt reports between 1996 and 1998. At this time, there was this widespread interest in Holocaust restitution, and it was acknowledged that many issues had been left unresolved during the Cold War, including the inability to research Holocaust issues or receive compensation for Holocaust-era property claims in Eastern Europe. And these could now be discussed and resolved with the fall of the Iron Curtain. So President Clinton asked his ambassador Stuart Eisenstadt to coordinate the preparation of a report on the status of Nazi looted gold and other assets. And when the reports were concluded, they covered issues including the scope of looting by Nazi Germany, the incomplete restitution processes after World War II, the flaws of the policies of the United States and other countries in searching for looted gold and properties in the post-war years, and the trade of gold and other assets by Germany with neutral countries during the war. So these reports, when they were published, propelled examination by other European governments of their own actions regarding Holocaust-era asset restitution, which we'll look at in a moment. But they also put the United States at the forefront of Holocaust justice initiatives in the late 1990s and early 2000s, with Ambassador Eisenstadt at the helm, brokering settlements with multiple countries concerning Holocaust-era looted personal property, such as insurance claims and bank deposits, as well as payments for slave and forced laborers. And the State Department's involvement in settlements with different European countries have continued well into the 21st century, and actually most recently include the French railroad settlement that Basler describes in his book. This was the agreement that Ambassador Eisenstadt assisted in brokering that was reduced to an agreement dated December 8, 2015. And the purpose of the agreement was to provide compensation to non-French nationals who were deported from France during World War II and had not been previously compensated by other agreements that had been put in place. And individuals were allowed to lodge applications until early 2017. And this particular settlement agreement came about because of a U.S. court case where an individual had brought an action against a French national railway seeking compensation for alleged violations of international law arising out of the deportation of Jews and other targeted groups during World War II. The suit was dismissed on sovereign immunity grounds, right? It was, as we discussed, the plaintiff couldn't find an exception to sovereign immunity for the National Railway of France. But bills were introduced in Congress that would abrogate the railway sovereign immunity anyway. And the lawsuit and the sort of legislative initiative taken in US Congress was viewed by France as creating a risk to the railway's business in the United States, because subsidiaries of the French National Railway subsidiaries do business in the US. And so given all of these sort of push and pull factors, in 2012, the French government sought settlement. And interestingly, as far as I'm aware, this is the only Holocaust asset settlement program that's actually being administered directly by the US State Department. While the United States is fairly credited with being a key facilitator of this second period of Holocaust restitution, there were many other international efforts as well as domestic efforts in European countries which assisted with this sort of second round of reckoning with lingering issues of restitution relating to the Holocaust. There were many international conferences that were held, the first of which was in 1997, and it was the London Gold Conference. It was followed up by the 1998 Washington Conference on Holocaust-era assets, which focused on movable property and fine art in particular, and led to the issuance of the non-binding so-called Washington Principles, which are sort of best practices for the restitution of movable property. In 2000, the Vilnius Conference was held, and it focused on cultural property. And in 2009, the Prague Conference on Holocaust-era assets was held, and it led to the non-binding Terezin Declaration, which for the first time addressed lingering issues relating to unrestituted, immovable, or real property. This resurgence of interest in Holocaust-era confiscations around this period led to the creation of numerous national commissions of inquiry in Western Europe that examined the extent of property confiscation in each country and the degree to which property was returned. For example, the Austrian Historical Commission in Austria, the Study Mission on the Spoliation of Jews in France, and the Van Kemenade Commission in the Netherlands. In general, the reports identified gaps in restitution or unfair or unreasonable consequences resulting from incomplete remedies for property restitution. With these commission findings, new national restitution mechanisms were established in some cases, or lump sum settlements were reached with domestic Jewish communities, for example, relating to outstanding restitution of communal or heirless property. One specific example is in 1999, the French government established the Commission for the Compensation for Victims of Spoliation, otherwise known as CIVS, to provide compensation to individual victims or their heirs who had not been previously compensated for damages resulting from legislation passed either by the Vichy government or by the occupying Germans. And as of 2018, CIVS is still open and processing a certain number of property claims. I'd like to conclude today by looking in part 5 at why the U.S. Holocaust restitution model, the four-legged stool, the access to U.S. courts that Basler described, failed to work for most other historical atrocities. So in this section, we're sort of looking at the framework that was built or attempted for Holocaust restitution in the U.S. and seeing how it applied or was applied or it was attempted to be applied to other historical atrocities. The first one that Basler looks at in his book is the Herero genocide litigation. And as I'm sure many of you are quite familiar with, between 1904 and 1907, there was the genocide of the Herero tribe in present-day Namibia by Imperial Germany. And Michael Basler describes this in his book, that this genocide came in the context of colonialism. The Germans were latecomers to European colonialism, but soon became the third largest imperial power behind France and Britain. Its colony in German Southwest Africa was founded in 1884, and as unenlightened colonialists, they sought to exploit the land for resources, expelled native populations from their land, forced individuals into slavery, and compelled them to shed their culture and tradition. And as an interesting note, Professor Basler notes that the colonial governor of German Southwest Africa was in fact Hermann Goering's father. So, unsurprisingly, by 1904, the Herero rebelled, and 65,000 Herero and 10,000 of a neighboring tribe, the Nama, were killed. Survivors were put in concentration camps, and medical experiments were performed on them as well. And looking, sort of fast forwarding closer to the present day, over the years, Germany has stopped short of making a formal apology. And in 2001, an action was filed in a US court against a German bank and a shipping company seeking $2 billion US dollars in compensation. German Deutsche Bank was alleged to have financed the enterprise that took place in Southwest Africa, and the shipping company was alleged to have used the Herero as slave labor. The case was dismissed. in 2005, a second action was filed and dismissed. And the the abiding differences between the Holocaust cases and the Herero was that these atrocities had occurred outside of the US more than a century prior to the lawsuit, and there were no victims alive to present their claims. Contrast with some of the Holocaust litigation where paintings were in the United States, individuals were alive to bring suit. There were more connections with the United States. The dismissal in the Herero case related to insufficient connections or contacts with the US. The fact that a German corporation conducted business in the United States was not sufficient to confer jurisdiction in this particular case. So for the Herero genocide, litigation in US courts was unsuccessful. What about using the Holocaust restitution model for Japanese industry reparation cases? During World War II, 36,000 American soldiers became Japanese prisoners of war. 14,000 Americans were captured by the Japanese, and roughly 26,000 American prisoners were sent to work for private Japanese companies, which now include Mitsubishi, Mitsui, Nippon Steel, and many others. Many cases relating to Japanese industry were filed in US courts, but in the end, the courts found that the 1951 peace treaty between Japan and its former enemies prohibited such lawsuits. The claims of the plaintiffs in these lawsuits had been settled through a treaty. If you recall, or if you know, states can espouse or settle claims of their citizens by treaty. A California state law permitting such lawsuits to go forward was also determined to be unconstitutional as improperly impeding on the federal government's right to conduct foreign relations. In addition to this court effort, US government conversation and diplomatic pressure also failed to yield any results. In 2015, Prime Minister Shinzo Abe acknowledged the damage and suffering that was caused, but failed to apologize for what happened. Basler describes that there is perhaps a door opening with respect to apologies from Japanese industry, and he provides the example that in 2015, Mitsubishi Materials became the first company to issue a formal apology for its wartime actions, and in 2016 apologized for the use of Chinese slave labor in coal mines, and for that offered symbolic compensation. I believe it was 56 million in total. So the suits failed, diplomatic pressure failed, but there may be the start of some acknowledgement on the part of Japanese industry beginning. What about African American reparations litigation? Like the Herero genocide litigation, the event in question happened a long time ago, more than 100 years ago. But unlike the Herero genocide litigation, it happened on US soil, making it less attenuated to bring a case in a US court for this type of reparation. So the thinking was, if US legal and political systems can facilitate 8 billion US in compensation for theft and slavery and other wrongs committed during World War II, then why cannot similar efforts be used to obtain compensation for slavery that occurred in the US, which, well, again, having concluded more than 100 years ago, whose effects still impact the African American community today. Lawsuits for this particular type of litigation were filed in 2002 against US corporations, where the allegations were that the corporations benefited from slave labor and sought, in just one of the lawsuits, $1.4 trillion in compensation, which was, according to those who filed the lawsuit, the estimated current value for unpaid African American slave labor. Litigation failed, but not on the merits, which is how most of these human rights abuses cases that are brought in US courts fail. They don't often fail on the merits because they don't often get to the merits. They usually fail on procedural or jurisdiction issues. And in this case, the court found the case to be time barred by a statute of limitations. And also, like the Herero genocide litigation, there were no former African American slaves to bring a case today. I put the quote that Professor Baszler included from Ambassador Stuart Eisenstadt in this lecture, and I liked it so much that I included it as a forum question today. And I'm interested to read your thoughts on Stuart Eisenstadt's suggestion that court cases for reparations was the incorrect remedy here for slavery, when he said, "I think the appropriate remedy is affirmative government action in general, rather than reparations. And if 100 years from now, the great-great-grandson of a Holocaust laborer asked for reparations, I don't think it would be appropriate, unless there was some specific property that had been confiscated that they wanted to recover." So my question to you is there a point at which the atrocity becomes too attenuated from the reparations that are sought? Armenian genocide litigation. Armenian genocide litigation is actually why most appears in parentheses in the subject heading of this particular part of the lecture, because there have been certain successes, certain numbered successes relating to the Armenian genocide litigation in U.S. courts. The first case that was successful was one called Marutian versus New York Life, and it was a case brought in 2000 in U.S. Federal District Court in California on behalf of persons who had purchased insurance policies at or around the time of the Armenian genocide that were never paid out. Does that sound familiar? It was based on Holocaust insurance policy litigation. The insurance company New York Life didn't dispute that it sold the policies, and it actually combed their archives for evidence of the sale of the policies, but amongst many defenses, they alleged that the policies contained forum selection clauses that required the cases to be heard in either Britain or France, and also they argued that the case was time barred. It was barred by a statute of limitations. For those of you who might not be familiar with Southern California is home to the largest Armenian population outside of Armenia, and California takes a special interest in the protection and the interest of Armenians. And a special California law was enacted to cover the two insurance company defenses in this particular case, including that no forum selection clause would apply and that the case was not time barred. But like the special Japanese industry litigation law, it was also found to be unconstitutional. There were also a couple other Armenian genocide litigation laws that were found to be unconstitutional. New York Life ended up settling the class action, however, for $20 million. And this was the first instance, the first success of Armenian genocide litigation in U.S. courts. The second instance of success was a case called Western Prelacy versus Getty Museum. This was a case I was actually involved in. And it was a 2009 action brought in California State Court by a branch of the Armenian Church for the return of portions of a sacred 13th century illuminated manuscript by Toros Roslin. The 8 illuminated canon tables appearing at the back of the Bible were removed for safekeeping during the Armenian genocide, and they eventually made their way into the Getty Museum's collection. The case settled on undisclosed terms, but in its press release, the Getty Museum acknowledged the Armenian Apostolic Church's ownership of the 8 13th century manuscript pages. And then separately, in recognition of the Getty's decades-long stewardship of the canon tables and its deep understanding and appreciation of Armenian art, the church donated the pages to the Getty Museum in order to ensure their preservation and widespread exhibition. The rest of the 13th century illuminated manuscript actually resides in Yerevan at the Modern Museum. So to date, these are the only two successful Armenian genocide cases. At least one case remains on appeal at the Ninth Circuit Court of Appeals in California and relates to stolen property that is now located under the Incirlik or NATO Air Base in Turkey. What made the U.S. courts in the 1990s a friendly forum in the first place for Holocaust asset restitution litigation? We have to look back to actually a case from 1980 to find the roots of this friendly forum in the landmark case of Filartica versus Peña Arala. It was not a Supreme Court case, but a case from the Second Circuit in New York, in which the court held that a Paraguayan national could sue a Paraguayan state official for acts of torture that occurred in Paraguay in violation of international law in a U.S. court, right? So check that out. Foreigner suing a foreigner for an act that occurred outside of the U.S. The decision was an endorsement of what we've discussed previously as universal jurisdiction. This is the idea that certain violations of human rights are so abhorrent to modern society that they may be brought to justice anywhere in the world. And this includes civil liability intended to those violations of international law. In the US, the basis of jurisdiction is a law called the Alien Tort Statute, which we discussed briefly when I mentioned the case of Jesner versus Arab Bank in Class 3, when we looked at how the Supreme Court was invoking case law from the later NMT trials. The Alien Tort Statute provides federal courts with subject matter jurisdiction over suits filed by aliens or foreigners in violation of the law of nations, essentially treaties or customary international law. And as Professor Baszler notes, while these were originally only crimes of piracy and crimes against diplomats, from Filartica onward, this was interpreted to include torture, genocide, and crimes against humanity. So against this backdrop, there was a more friendly forum for litigating the atrocities of World War II in the 1990s. What was the beginning of the end for universal jurisdiction in U.S. courts? Again, this doesn't necessarily relate directly to the bringing of cases relating to Holocaust restitution in U.S. courts, but relates more to the appetite of U.S. courts for becoming clearinghouses for the world's human rights violations. And we see this in the 2013 U.S. Supreme Court case of HGAIL versus Royal Dutch Petroleum. This was a lawsuit filed by Nigerians against Shell Oil Company for allegedly aiding and abetting the Nigerian government to commit gross human rights violations to promote oil drilling. And the Supreme Court found that the case could not continue under the Alien Tort Statute because the Alien Tort Statute was not available for so-called foreign cubed cases, where the plaintiffs, the defendants, and the alleged actions were all foreign, so occurred outside of the U.S. The court applied the presumption against extraterritoriality, where unless Congress so states otherwise, laws passed by Congress are to be interpreted to apply to conduct in the U.S. only. In this case, in HGAIL, the Supreme Court created a new test for ATS jurisdiction, that even where claims touch and concern the territory of the United States, they must do so with sufficient force to displace the presumption against extraterritorial application. The Supreme Court essentially barred cases based on purely extraterritorial conduct, even if based on universally condemned conduct under international law. But the HGAIL versus Royal Dutch Petroleum case did not close the door on all cases involving foreign conduct and foreign defendants. There are still, for example, a number of cases relating to Holocaust-era asset recovery that are alive in U.S. courts against foreign sovereigns or their agencies or instrumentalities. These cases have not been brought under the Alien Tort Statute, but under the Foreign Sovereign Immunities Act, which is the sole basis of jurisdiction in U.S. courts over foreign sovereigns, so foreign countries. And we discussed this in the context of the case of Maria Altmann versus the Republic of Austria, the Gustav Klimt painting case. Examples of cases that are still alive in U.S. courts relating to Holocaust asset recovery include the case of Simon versus Hungary from the D.C. Circuit. This is a class action suit against the Republic of Hungary and its state-owned railway, which were alleged to have collaborated with the Nazis to exterminate Hungarian Jews and expropriate their property. Another case is Philipp versus Germany, which is a suit by successors of an art dealer consortium against Germany and its state agency administering museum, where art allegedly sold through coerced sale as part of Nazi persecution of Jewish sellers is currently being exhibited. A final example is the case of Kassierer versus Thyssen-Bornemisza Collection Foundation, which is a case in the U.S. District Court for the Central District of California, and is set to be one of the first trials in the U.S. relating to Nazi-looted art if it actually goes forward as planned in December of this year. The plaintiff, Kassierer, is an American citizen whose grandmother's Pizarro painting was allegedly confiscated by an agent of the Nazi government in Germany because she was a Jew. He filed suit in federal court to recover the painting or get damages, so restitution or compensation, from the Kingdom of Spain and the Thyssen-Bornemisza Collection Foundation, an instrumentality of Spain, which now claims to own the painting. There are a number of other cases in addition to these highlighted as well. As we conclude for this week, I'd like to leave you with this final thought or question. What made the United States fertile ground for becoming a key facilitator in the second wave of Holocaust restitution and compensation efforts between the 1990s and present? And going forward, should any remaining efforts be driven by U.S. courts and/or U.S. political pressure, or should Europe or others take up the mantle? Thank you.